We're live.
Good morning. This is the House Judiciary Committee a little after 10 o'clock on the 10th of April, 2021. There are several bills here that we have on the voting list. We have several bills for which there's concurrences and requests not to concede or to not receive. So why actually, let's go ahead and we've dealt with some of the bills that are in a different posture from the Senate in the past. I'm going to go ahead and run through, well, I'm not sure if this is one of them, but we'll run through a couple. One, I think we did do this for Senate Bill 105. Senate Bill 105 was Senator Sidnor's bill. The cross-file is Delegate Atterbury's bill on workplace violence. I think we did the conference committee on, we assigned a conference committee for the House bill. So now we're assigning a conference committee for the Senate bill. And so the motion here would be to not recede. And the three members of the conference committee would be Atterbury, Shetty, and Williams, just as it is on the House bill.
Move
So-
what you just said.
Mr. Chair, so yeah, I'm trying to get the file. So now will we be able to get the file? Because we have an agreement with the Senate.
Okay, yeah, I mean, once we do this, once it's read across, we should be able to get all of that up and moving. So we'll do this right
Okay.
now and Dylan tells me we will process it right away. So the motion is not to recede. Is there a second?
Second.
All in favor of not receding and assigning the conference committee that was listed, please raise your hands. Look at Shetty, Atterbury, Conaway, Crutchfield, Davis, Cham, Williams, Watson, Griffith, Graham, Cox, Bartlett, McComas, Malone, Jones, Lopez, Cardin, and Moon. All right. Well, and I didn't see anybody with their hand down, so we will not recede and we'll get that on the move. Senate Bill 43 is the issue related to police officers. Prohibition. Delegate Fisher, you need to go on mute. Law enforcement officers and a prohibition on sexual activity. We already did the House bill. This is now the Senate bill that has come across from Senator Elfreth. So again, the motion is not to recede.
Move not to recede.
The motion not to recede. Is there a second?
Yes.
All right, motion to the second. All in favor of the motion not to recede, please raise your hands. Delegate Shetty, Atterbury, Cham, Conaway, Crutchfield, Davis, Williams, Watson, Cox, Bartlett, McComas, Malone, Jones, Lopez, Cardin. Anybody opposed to the motion not to recede?
I was a yes on the previous motion.
Yes, on the previous one. Okay. Griffith is a yes to not recede. That's fine. All right, we are assigning conferees. They are Williams, Moon, and Griffith. Senate Bill 250 is Senator Lee's bill. This is the bill where literally everyone wanted to be on the conference committee. Senate Bill 250, fourth degree sexual offenses and spousal defenses. The Senate has assigned a conference committee, so the motion is not to recede.
Move not to recede.
And is
Second.
there a second? All right. All in favor of not receding? Delegate Cardin have a hand up. Do you have a question about not receding?
I do not want to be on the conference committee.
Great. All right. So the motion is not to recede. All in favor of not receding, please raise your hands. Delegates, Shetty, Cham, Atterbury, Conaway, Crutchfield, Davis, Williams, Watson, Griffith, Cox, Grammer, Bartlett, McComas, Malone, Cardin, Jones, Lopez. Anybody opposed to the motion not to recede? Don't see anyone in opposition. The conference committee, Crutchfield, Shetty, Arakan. House Bill 23 came over from the Senate. They made a technical change to the bill. Holly, could you please tell us what the technical change? House Bill 23 is the bill, the Maryland Driver Privacy Act. It has to do with access to records from MVA being given, I think, to immigration. House Bill, so Holly, are you?
Yep, I'm here. So all it does is they clean up the database definition, and then it just cleans up the language revolving certain information going to a federal agent or federal agency. And that's all it does. So Delegate Stein, I was talked to him last night. He is fine, and ENT is okay with this as well. This was a joint bill.
All right. So they've solved the problems. We had already solved the problems with reports, with other agencies. I think we've got this tightened up. Like a motion to concur.
Move to concur.
Motion to concur. Is there a second? Motion to the second. All in favor of concurring with the Senate's amendments, please raise your hands. Delegates Shetty, Atterbury, Cham, Conaway, Crutchfield, Davis, Williams, Watson, Cox, Bartlett, Cardin, Fisher, Jones, Lopez, Moon. Anyone opposed? Seeing McComas
I'm going to be opposed.
and Malone and Griffith. All right, the motion to concur is adopted, and that will go to the floor. I have another one here, and it's House Bill 316. I think we'll take that up in a moment because I'm still dealing with some feelings about that. Senate Bill 515 is on your voting list. We started talking about this yesterday. What I'd like to do is talk about it a little more. And I don't want to slow this down, really honestly, more than absolutely necessary, but because I think we're very close. But one of the issues that was raised yesterday was with regard to the Senate amendment that would allow for a non-public option for these people who are registered sex offenders, but who still qualify for high school, that they would be able to go to a non-public educational program as provided by 8406 of the education article. We received information, and it's the information that the Senate received from the organization MANSEF. And I'm not going to put Delegate Cham on the spot, but she is familiar with that organization. There are 70 schools apparently across the state that do provide services to people in these situations. Their concern, and the reason that they went to the Senate, their concern is that the bill as we had sent it would block them out of the process and would keep them from being able to provide services that they're already providing to these kids. And it does include kids who are on the registry. They also serve other kinds of kids too, but they do this, they provide the service and seem to know what they're doing to keep kids separate who are on the registry versus people versus kids who might be who might have special needs. Delegate Arakan is on the call too, and I'm just going to say we are talking about Senate Bill 515 right now. Delegate Arakan.
Mr. Chair, can you tell us what section 8406 of the education article is?
I will go right over here and find it. One moment.
Thank you, good sir.
Unless Delegate Cham can answer the question, then that would be great.
You're muted, Delegate Cham.
I'm trying to reference it myself, see if I can.
Chair, I can generally say that you can be more specific, but it's generally providing special education services for certain children who may have certain disabilities.
Right. That's my understanding as well. They receive, I think the difference is that they receive public funding. I think is these are not boost schools. These are schools that receive public funding because these are kids with certain special needs. 8406. It addresses the placement of a child with a disability in a non-public educational program.
Yeah.
The basis for placement is in 846B1, a child with a disability who needs special education and related services that cannot be provided in a public county, regional, or state program shall be placed in an appropriate non-public educational program that offers these services. That's a short description of of what we're talking about in 8406. So I'll start with Delegate Griffith, then Delegate Cham.
Hey, Mr. Chair.
Yeah, go ahead, Delegate Griffith.
No, and this was the concern I raised yesterday, something that was very concerning to me. But between my conversations with you and Delegate Cham, I believe my concerns have been answered, and I'm comfortable moving forward.
Okay, Delegate Cham.
Thank you, Chair. Yes, so just to quickly reiterate, if students aren't able to have their IEPs, which is an individual education program, implemented in a least restrictive environment that may be in a public school setting, then that IEP team can convene and find other continuum of services that may likely be a non-public school, but those schools are funded by public school monies. My experience has been in the non-public school setting, and those are the children that are really most challenged with the disability. They're often in school till the age of 21. And some do make it back to public school and some don't. But certainly that's where your most challenged youngsters are being educated, in that non-public school setting. So
would it be safe to say, Delegate Cham, that, I mean, we deal with kids with a variety of different issues? So it's kids who may have severe learning disabilities, kids who may be on the autism spectrum, kids who may have other issues. And it would be safe to say, and I see you, Delegate Cardin, it would be safe to say that and they indicate we're going to provide a copy of the letter that Mansif sent the committee here in a little bit, so people have a chance to look at it.
mm-hmm.
But people who are on the sex registry would kind of be another subset of kids that these schools deal with, that they don't necessarily mix these people together. They keep them basically separate.
Correct. You have a lot of non-public schools that some tend to, because my area of expertise, if you will, is students with autism. And the schools that I've worked in cater to the needs of students with autism or students with an intellectual disability. You wouldn't put in students with, sex, who have made sexual offenses, or who might be behaviorally challenged through an emotional disability. You wouldn't put those kids in the same school. Then you may have a school that cater to the needs of children who have an emotional disorder. So there are many schools under that Mansif umbrella where they sort of, school systems will decide, okay, this student has autism. This Mansif school is a great school to place that student. This student has an emotional disorder. Let's go with this school to choose for the rest of their schooling. So yeah, it's crafted very individually for the individual.
All right, thank you very much for that. Delegate McComas.
Thank you, Mr. Chair. This is for Delegate Cham as well as Delegate Cardin, and maybe if we could get a little more information. So I'm just kind of concerned that there's a full vetting so that none of these folks would be in with kids that have diminished intellectual capacity or physical capacity, or, or autistic. They may be very smart and very, very artistic or musical, but that's my concern. And then the other thing is that, okay, if you put all of the folks that are older with criminal charges of sex crimes and everything, is that kind of, what is preventing them from attacking each other or victimizing each other too? So I guess, it's almost like you need a really supervised environment for the kids. So I just kind of throw that out, because obviously we want these kids that did commit the crimes, the sex crimes, to get better and realize that they need to change their ways if they can. So just what information do we have?
May I, Chair?
Sure, please, Delegate Cham.
So Typically in these non-public schools, the staff to student ratio is very high. You may have a classroom of 6 in very small classrooms. 6
You mean
students-
very, very small? You mean very low?
very small, right?
2 to 1, 3 to 1. Okay, got it.
Right, very small classroom settings. If it could be 6 students in a class, and they all may have their own support staff working with them. So one-on-one. Now that there's a lot of research there that talks about that one-on-one, it creates dependency in students. So again, it's all based on the individual and what that particular student needs for their programming. But when you have a lot of adult support in that classroom, in that school, you have a lot of resources within the school. You have social workers, you have psychologists, and you have, psychiatrists at your use. So it's a lot of resources and a lot of additional staff that keep these schools afloat. A lot of support. Really, a lot of support, a lot of adult support. So that's very helpful in that respect. When you're working with children who have very challenging needs, they need a lot of support and then need a lot of additional support. So the support is there to answer your question.
Seems like these programs are actually best suited for this universe of people. But Delegate Cardin, and then Williams, and then Cox.
Thank you, Mr. Chair. Just to follow up on a little bit of what Delegate Chan was saying. So I have anybody who wants to see it, the ManSEF directory with contact information for every single member of the ManSEF group here in my office. I'll bring it with me today. ManSEF represents 70 schools, over 3,000 of Maryland's most challenged students and their families. They employ 2,200 clinical and administrative professionals and 1,700 classroom teachers, therapists, and assistants. The most important thing for Delegate McComas, the schools provide individualized education in accordance with COMAR as required, and give families across Maryland peace of mind and hope that their children's education will be done properly based on their needs. They also provide both online and in-person education depending on the needs of the student. I have a list of all their 70 plus institutions, some of which are, for example, Shepherd Pratt here in Anne Arundel County. Let's see, in Hartford County, Arrow Center for Education, Riverside, and High Road School of Hartford County. The executive director comes here every year to advocate. They are a nonprofit that is funded by the state to be able to provide special education as required by whatever rules we create to provide the best education for the people that need it and cannot be serviced in the public school realm. So if this isn't exactly what we're looking for, it seems to me like it was great that they kind of surfaced in the Senate legislation, and I would recommend we move forward, and I can answer any other questions or provide this information to everybody. I happen to know the exec director very well, and she is always willing to figure out how to work to help us educate people that need to be educated.
All right, Delegate Nicole Williams, please.
One, thank you, Delegate Cardin, for flashing the book. When you did it, I realized I had my own copy on my desk. So I actually partially kind of answered my own question, which was one, kind of how many of these schools exist here in the state. I guess my question or concern, and I don't know if Delegate Cham or someone else can answer this, is I do see there's a number of schools all throughout the state. I guess my concern or question is, how easily is it for, if I had a child who needed to be placed in one of these schools, how easy is it for me to be able to get my child placed in the school? Kind of what's the time frame? Also, in terms of accessibility, if I live and I see that they are broken, some of the schools are broken down by different specialties, whether it's autism, multiple disabilities, emotional disabilities, hearing impairments, things like that. But what if I live, say, in a county where I need a school, where my child needs a school that specializes with hearing impairments, for an example? What resources are in place to make sure that that school is still accessible to my child in terms of me being able to get my child to that facility, those types of things. I guess that's just kind of one of my concerns, because there are a variety of different counties, some public transportation, some may not be public transportation accessible. So I guess I don't know if you're able to answer that or not.
May I, Chair?
Yes, Delegate Cham.
Okay, so I've been a director of education at 2 of these non-public schools in my professional career, one in Montgomery County and one in Howard County. And generally what happens is if a child has an IEP in their public school setting and the school has determined that they cannot, with all of the resources that they have at their disposal in that public school setting, they still cannot successfully implement that IEP. The IEP team is going to come together, have that conversation, and determine what's an appropriate non-public school that we can look into to consider placing that child. So some options are considered. Most often the non-public school representative will come to the next meeting because that's a potential school where the IEP team might be considering. The parent is going to go out and visit that school. The child may go out and visit the potential school. There's a lot of pre-work that's done for the transition. Now, you may come to a place, the IEP team may come to a place where there is not a school close enough where the child can ride the school bus and be transported to attend that new non-public school. Sometimes that does happen. The programs where I worked also had a residential component to it. So the child lived in a group home setting with other peers that are of typical challenges or behaviors, if you will. And that's only if a residential component is needed. It's not always needed for every child. So that's something that the IEP team must consider. So the goal is always to try and keep the child within their school community. Always try to work to do that. That's who they play with in the community. That's who they spend time with. That's who they, go to school with. But if that cannot happen, then we look at other, that spectrum, we look at that continuum of service to determine, okay, what's the next best option for this child? It is encouraged not to go, 0 to 100 too quickly, but you kind of look at that gradual continuum of service. What's the next best option for this child? So IEP teams really are tasked with making very big decisions on behalf of children, because we want to look at least restrictive, not anything that's most restrictive. Because once they finish school, either they're going to work in the community like you and I work and make a paycheck and pay taxes, or they may be in a setting where they might need more supports at that adult services component. So that's pretty much how it works. The IEP team is tasked with making those decisions regarding finding a potential program, a potential school where that child is going to hopefully be successful, and the school can implement the IEP with all of the resources and supports that they provide.
All right. Delegate Cardin raised his hand again during that conversation. No, you didn't? Okay, that's fine. Delegate Cox.
Thank you, Mr. Chair. And I'm so glad Delegate Cham is part of this discussion. It's very helpful. So some of the things that came to mind as Delegate Cham was explaining this excellent process that does exist is the fact that last year, I think it was, we had a bill, pardon me, that would have disclosed juvenile registrants, and there was a concern about disclosure. I think the vice chair made a point that we didn't want to have stigmas attached to these kids all their lives. So I guess in looking at the registry list, this doesn't seem to explicitly identify the difference between the two different registries, whether there's an adult registry, in other words, a juvenile or an adult registered sex offender attending versus the juvenile registry list, which is confidential and not disclosed. And in the context of that, I looked up this education article that we're discussing, which is very helpful. And and correct me if I'm wrong, but it doesn't expressly provide the specifics for allowing a child who is a juvenile sex offender to be properly placed. It's in terms of explicit statements. I mean, here's what it says. It says B1 says what you quoted, Mr. Chair, and then that if the related services cannot be provided, this is 8406 B1, in a public county, regional or state program shall be placed in an appropriate non-public. It doesn't expressly explain what cannot be provided. And then you go to number 2 and it says a child with a disability who needs special education is eligible for the non-public placement for two circumstances. 2I says because of the child's home circumstances, which is undefined, or because of a medical necessity. And so anyway, the idea came to mind that maybe we should specify in the statute, in this proposed bill, if you look at the bill, page 3, and you go down the list, it says that you can only be a child can only be placed in the non-public program if, under 8406, if the registrant has notified an agent, which brought to mind the vice chair's concerns about disclosure, and the registrant has been given specific written permission by an agent or employee to attend it, which seems to be discretionary, and so some of these kids may be denied. So those are some of the thoughts that came up, and I thought if we tightened it with specific language that would say whether or not they're on the juvenile registry or the adult registry, a disclosure needs to be narrowly provided and must be provided. And then when the placement happens, there needs to be guardrails to make sure that what happened in Washington County doesn't happen again, like we discussed last year, where the child was unknowingly placed on the bus, might have been in a program, might have been in a wonderful program, but unfortunately during the bus ride, apparently assaulted again. So those are some of the thoughts that came to mind when I was looking at the specifics, and I apologize. I know it's more complex, but I think it merits at least a little more careful consideration regarding these guardrails that we're all trying to ensure take place.
I think that the guardrails that the Senate amendments made are I think that what we've learned here today, and I do want to thank and we don't get into issues related to education on this committee generally, but I do want to thank Delegate Cham for sharing with us her vast knowledge in this area, and appreciate that. The point of the bill is making sure that registrants don't go to regular or to the issue goes back again to what happened in Perry Hall, and that the student returned to the school because he was eligible for the school, but because he was, I think, 18, but he was on the registry. So what became clear was that there was nothing that was keeping that child from going there, and that what was needed was other options for the kid to, or in this case, and I think these are mostly people who are 18 and over because they're on the registry. So we're not dealing with people who are under 18. We're dealing with these kids needing an alternate place to go, and that's why we set out the home and hospital program, a program approved by a county board, a regional institute for children and adolescents, and now the Senate adding the non-public educational program. So I kind of feel like that this has got enough belts and suspenders on that side of it right now. Delegate Cox, we have received a further amendment from you that is not necessarily on topic with this issue, and I didn't know whether you intended to press that amendment.
Well, I did because it goes to the safety. I mean, you made a good point that the intent of this bill is only for adult sex registry issues.
Basically 18 to 21. The 21, they can't.
Right.
Yeah, we don't have to provide a high school education to people over 21.
And that was the issue. That was an issue that it didn't seem expressly clear to me because there are two lists in Maryland. There is a juvenile sex register, as you know. But if you wanted me to talk on my amendment, I can do that briefly if this is the appropriate time. So, as you know, I presented this this bill before, and it is a very concerning bill to my constituents, concerning issue that is directly on point with access to schools by those on the sex registry list. And this just simply would put in there that a sex offender who's on the sex registry list may not live within 1,000 feet of a school. And the amendment was intended to fix one of the concerns at the hearing and strike 3 through 6, which I have done on my copy. So if you look on page 2, I'm offering only point 1 and 2, a school or a child care facility. 3 through 6 were supposed to have been stricken, but didn't happen in the rush to get this to you. But as I mentioned before, there are 38 states with this protection of our children, 38. So Maryland is one of just a handful of states that hasn't done this. The average state is 1,000-foot buffer around a school or a child care facility. Some of them are 3,000 feet. Some of them impose incredibly restrictive standards and very, very involved. This is a simple approach that has a direct and relevant correlation to sex offenders living near schools and entry onto property at schools. And so for that purpose, I would press the amendment.
Delegate Cox, is there anywhere in the city of Baltimore that is not within 1,000 feet of a school?
I would not know that answer, Mr. Chair. That would be something that I would defer to you, since I think you would. I've worked in Baltimore, and I certainly haven't seen schools on every corner, but obviously there are quite a number of schools.
And there are quite a few childcare facilities in the city of Baltimore. So that this would apply to the city of Baltimore and to other urban parts of the state, the way that I read this is that it would move people who are child sex offenders from the city of Baltimore and from other urban areas of the state to places that are perhaps more rural.
Well, I don't know that that would be the case. I don't believe that
they wouldn't be able to live in the city of Baltimore anymore. They
well, if your assertion is correct,
Baltimore County.
If your assertion is correct, then I would proffer that I'm not fixated on 1,000-foot buffer. I mean, there are some states, I think Delaware is 500 feet. I would be happy with that. I know my constituents have mentioned that as a compromise. But this is common sense. It's it's ensuring that our kids are safe. And this has a practical concern in my district with a registered sex offender living within 1,000 feet of, I think, a very established child care facility, and allegedly using cameras as part of his security system that are catching kids on the cameras. And this is something that has been a concern locally for my constituents. It's been a very serious concern also across the country, as I mentioned, with 38 states making sure that our kids are safe with this. And I think that it's a common sense approach to making sure that those who are on the registry lists, it's prospective. So those who from the date forward are put on the registry list are not allowed to move into those communities.
Delegate Cardin.
I just very quickly, So number one, would this include the students that we're discussing in this bill as well, Mr. Delegate Cox?
I'm sorry, you broke up on me right as it,
Right. Would this also include the students that are included in the original bill that we're trying to service?
that's an excellent question. And let me look at my amendment.
And the reason I ask is because if that is true, then these students that have just been assigned to a school aren't going to be permitted to go to that school, number one. Number two.
No. My amendment is residents only. So permanent residents.
Right, but we're creating a system where students can go to school, and your amendment is denying them the ability to go to school.
No, that's not true. It's not denying them the ability to attend school. It's denying them the ability to prospectively to live within a zone of school where lots of kids
So
are
they can go to the school, but they just can't live near the school that they're going to.
And that's, I think, the point of the discussion here. We're trying to make sure that the bill that we pass doesn't allow for these continued rapes and serious sex offenses to occur because of individuals being permitted easy access to our schools. That's the whole point, I think.
So I mean, there are playgrounds, and at least in Baltimore County, we have got playgrounds at least, I mean, maybe not every 1,000 feet, but in suburban areas, there's essentially, you're essentially basically saying that registered sex offenders cannot live.
I struck that out, Delegate Cardin. As I mentioned, only point 1 and 2 was the intent of the amendment. 3 through 6 is stricken.
Okay. All right. I mean, I would strongly urge just to it seems like a separate bill. This is really, I mean, we're talking about
In fact, was a separate bill, but yes.
Oh, if in that case, I would just ask us to resist amendment. Enough.
Delegate Cham,
Trying to unmute here. Okay.
you got it.
Thank you. So for Delegate Cox, thank you for your amendment. I know it comes from a place of good intentions. I heard from Dory Flynn yesterday via email. As I stated earlier, she sent me an email and she also sent me the letter. And she's the executive director for the Mansfield schools. And in her email, she stated that the Mansfield schools currently have schools where students who have committed such crimes and are on the registry, but under the age of 18. It could be 16 or 17. So with that, they probably live at home with mom and dad. So what do we do with those students regarding your amendment to that they can't live within a certain footage of a school setting, but if they're 16 years old, or are we focusing on students 18 and over?
Well, thank you, Delegate Chan. It's an excellent question. So first of all, the amendment is prospective, so it doesn't apply to where people live now. It's only where they would move to in the future. So you can't move into a school zone. Secondly, as to the application of juvenile registries, this is specific to the state sex offender registry list. I would have to look to see whether or not that would be inclusive of the secret juvenile list, but as you know, that's only accessible by the law enforcement personnel. I think it would probably and should apply to both registries and would be prospective, so that a parent needs to be aware if they're going to move into a community and they have a registered sex offender who raped or otherwise committed a sex offense, that they need to be aware that they shouldn't be moving next to a school where that child of theirs would have daily access to our children, potentially unsupervised. So I think that would be the intent, and it's also a common sense thing. Like I said, 38 states do this, and it is not good that Maryland is dragging up the rear in our forward-looking approach to protect children. So With that, I would press the amendment, Mr. Chair.
You know, I appreciate what you're trying to do. I think inadvertently you're look, it's never easy to talk about the rules related to registered sex offenders. And again, we deal with very difficult issues here. So this is one of them, because we have to talk about these things, and they are very difficult to deal with. There are existing rules that parole and probation already have, and normally as part of sentencing, a judge will set restrictions on how close somebody can be to a school or a childcare facility. I will say that the amendment as it was initially drafted and the bill as initially drafted was broad and arguably would have left people on the registry either completely hiding from public view, which, you know, it's not advantageous for me to be advocating that for necessarily the rights of sex offenders. Having said that, it would force them to go underground, which could have some even more negative effects, because parole and probation, they have existing people who specialize in the management of sex offenders, and it's important that, yes, we in fact know where they are. But I'll go back to the other reason that I led off with. I think inadvertently, not to put a fine point on it, I believe that we would be moving child sex offenders effectively to the rural parts of the state. I think that you would be moving them, quite honestly, with genuinely no disrespect, we'd be moving them to your district, Delegate Cox. Is that what your constituents want? Because they wouldn't be able to live in big parts of the city of Baltimore, big parts of the urban belt in the middle of the state. They'd have to go somewhere where they weren't within 1,000 feet of all these things. I'm not saying they should live within 1,000 feet of them, but we have to, that flexibility is there, and it allows the judges to say, no, you don't get to live within 1,000 feet of a school or a child care facility. It brings me no joy to argue against against an amendment that would keep sex offenders away from a school and a child care facility. We already have, in fact, the reason we're on this bill is because we are seeking to keep registered sex offenders out of high schools. That's what we're seeking to do with this bill. But adding this, I think, creates a wide range to steal from Delegate Griffith from a couple days ago, unintended consequences that we don't, I don't think we can properly address with this kind of legislation.
Well, thank you, Mr. Chair, for your comments, and I respect them, and I appreciate your concerns. I would mention, just as a matter of interest, that my district represents the second largest city in Maryland, and my district is one of the largest districts in Maryland. It actually expands down to one of the fastest growing communities of over 130,000 constituents, and actually Frederick County is over 250,000 people. So we have large urban areas as well that I represent. And I'm not just, speaking as to trying to move kids out of urban areas. I think that when you look at states such as California, I mean, it's not a very non-progressive state. In fact, it's one of the, I would think many would agree, one of the more progressive states in America. And it has a 2,000-foot buffer for all sex offenders of any school or park. And then if they're a high-risk sex offender, it's a half a mile. So we're not talking unreasonableness in terms of protecting our kids. And I think, that I think it can be done in a way that, like I said, that this is prospective and protective of our children, and will not create any unintended negative consequences. But I do think if we don't have this common sense approach, and that's why I decided to, and I appreciate the chair allowing me to bring the amendment, because if we don't have common sense approaches to making sure our kids are safe on school properties, we have the evidence already in our hands. We know what will happen. Those unintended consequences will be more rapes, will be more sex offenses against minors, and will definitely harm our kids. We have that evidence. So that's why I'm presenting this, to protect our kids, and my constituents firmly and strongly support this. This is the strongest piece of legislation that my constituents have come forward with requesting this year. And so I thank the chair, and I understand the concerns, but I think they're alleviated with the way the country is going to make sure we protect our children. But thank you.
Delegate Arakan.
I'd like to move the previous question on the amendment, please.
I'd second it. Thank you, Mr. Chair.
All right. I'm going to hold the bill. And I'm going to take a look at this again. And you know, there are a lot of parts of the criminal procedure law, parts in the registry where that make this unnecessary. This will have a range of unintended consequences. And so I'm going to hold the bill.
Mr. Chair,
We'll come back in the afternoon. Delegate Moon.
can I amend, can I amend an amendment? And if so, what's the process for doing that? And I'll just tell you what I'm thinking about, since we're expanding new concepts of safety onto bills that have already passed. I want to add that if you are prohibited from possessing a firearm, that would also be added to the bill, to the amendment.
All right, we're going to stop on this bill right now and we'll come back. And I understand that there'll be further questions. All right, we're going to go now to two other bills, House Bill 899 and 902. House Bill 899 is the House cross-file, and 902, they're the House cross-files of the civil jury trial, the amount in controversy. There are amendments from the committee to lower the $30,000 to $25,000, just like we did with the Senate bill. So what I would like is we'll treat these two amendments because they deal with the same parts of both bills. I would ask for a motion to change the amount from 30,000 to 25,000.
So moved.
There's a motion. Is there a second?
Second.
All right, motion and a second. All in favor of conforming effectively House Bills 899 and 902 to their Senate counterparts, please raise your hands. Delegates Shetty, Atterbury, Conaway, Crutchfield, Williams, Watson, Bartlett, Moon, Davis, Cardin, Jones, Lopez, Fisher. All those opposed? Delegate McComas, Cham, Grammer. All right. And Griffith. All right. So we're on the bills as amended.
Move the bill as amended.
Motion for the
I have an
bills as
amendment.
amended. And Delegate Malone has an amendment. That's right.
I'll be fast. It's the same amendment was for the other bill to make the amount 20,000. I pressed the amendment.
All right. It was his amendment to make it 20,000. The chair opposes the amendment, would ask the committee to resist. So all in favor of Delegate Malone's amendment to make it 20,000, please raise your hand. Delegates Cham, Griffith, Cox, McComas, Can, Malone, Grammer. All those against Delegate Malone's amendment, Delegates Shetty, Atterbury, Conaway, Crutchfield, Williams, Watson, Bartlett, Fisher, Davis, Cardin, Jones, and Lopez. All right, so now we're on the bills as amended. We'll take them together because they are effectively the same thing, just one is the enabling language, one is the constitutional amendment. So we'll do one vote on 899 and 902. Can I have a motion for both bills?
Move the bills as amended, please.
All right, is there a second? Motion and a second. We had extensive discussion yesterday. The vice chair,
Yes.
Arakan,
Yes.
Bartlett,
Yes.
Carden,
Yes.
Conaway,
Yes.
Cox,
No.
Crutchfield,
Yes.
Deborah Davis,
Yes.
Juanita Fisher,
Yes.
Grammer,
No.
Griffith,
No.
Rachel Jones,
Yes.
Lopez,
Yes.
Malone,
No.
McComas,
No.
Moon,
Yes.
Shetty,
Yes.
Sham,
No.
Watson,
Yes.
Williams.
Yes.
All right, the amendment is adopted, or the bills were moved favorable, I should say. 14 to 6. All right, those are those two. All right, we'll come back to 5:15 a little later today. I think that's, I'm looking to make sure there's nothing else I have to do.
Is session still 11:30?
Session's still 11:30, so with that, we will stop. And this has been a voting session of the House Judiciary Committee. We will be back this afternoon. Thank you.